they are unconstitutional. Thank you very much.
Thank you very much, the Honorable Justice Joaquin Dongo, for rendering your opinion. It is now my pleasure to invite the Honorable Mr. Justice Wanjala to deliver his opinion.
Thank you, Chief Justice and President of this court. Mine is a summarized delivery of my judgment, because I know that, I expect counsel to read the judgment. But even if you don't read, I know that out there are Kenyans who will read it and contribute to the growth of jurisprudence in our country. And so I begin by also acknowledging the fact that I have perused the lead judgment by the President of the court, and I'm in agreement with how the contents of the background have been captured and the submissions by the parties have been paraphrased. And so this enables me to immediately go into the consideration of the 7 issues that we formulated for ourselves with your concurrence. But before I do that, I must also pay my gratitude to our colleagues at the High Court and the Court of Appeal for their gallantry and industry which they invested in this enterprise. It's due to those efforts that at this stage, I can say we now find ourselves in the fog of the season's end, for those of you who read beyond the legal text. And now to the first question, whether the basic structure doctrine is applicable in Kenya, and if so, to what extent? And I begin by acknowledging the fact that never since the promulgation of the Constitution of 2010 have our courts been confronted by so polemical, elastic, and indeterminate notion as the so-called basic structure doctrine. And it all began with when a group of distinguished citizens, aggrieved by what they perceived was an imminent overthrow of the Constitution, approached the court, the High Court in particular, seeking its intervention to stop that overthrow. And I've also, like my colleagues, traced the origin of now what is being called the basic structure doctrine. And I don't think I need to go into the stages, the historical stages of how this notion, in my view, sprouted and continues sprouting in parts of the world. I think that my colleagues who have spoken have done a sterling job, and I do not intend to retrace the history of this doctrine. But I do ask, how did we find ourselves enmeshed in this kind of theorizing? Because right from the High Court and now up to this court, what we appear to be doing when addressing this notion of the basic structure of the Constitution is really a preserve of legal and social science scholars. It is hardly an occupation of a court of law, not to mention an apex court of law like this one. So how did we find ourselves in this process? It's because there can be no doubt that in approaching the court, the petitioners had been aggrieved by what they perceived as an imminent threat to the Constitution posed by this amendment bill. But instead, what they should have done, in my view, they would have laid down a prayer in which the alleged, the fear of violation of the Constitution, and in support thereof, they were at liberty to deploy any arguments, propositions, and analytic tools to convince the court that indeed such a declaration was warranted. But instead, what we have here is a fundamental departure from a long-established tradition of invoking the jurisdiction of the High Court. The petitioners instead presented the court with a theoretical construct, a fait accompli, whose declaratory validation they sought. And unfortunately, the High Court elevated this proposition as designed by the petitioners into an issue for determination, even at a preliminary level. And later they would be joined by our colleagues at the High Court. But be that as it may, now that the applicability of the basic structure doctrine in courts has snowballed into a ubiquitous inquiry, we at the Supreme Court may not, without stirring justified indignation, disregard it altogether. And so I have been compelled, just as my colleagues have been, to go into an exegesis of what then is the anatomy of this basic structure doctrine. I have asked myself whether indeed it is a doctrine, juristically speaking. I have come to the conclusion, after not just a soul searching, but serious thoughts, that what we are faced with as a basic structure doctrine is no such doctrine. Instead, it is what I consider as a school of thought, or at best, a heuristic device, which a court of law, when faced with the question as to whether a proposed constitutional amendment is of such a nature as to destroy, destabilize, or distort the constitutive authority of the Constitution, a court of law faced with such kind of question can deploy this heuristic device in its effort to answer the question. But I find no fault with this rich and diverse array of opinions, so eruditely crafted by some of our finest in the judicial system, the legal profession, academic institutions, and from far afield by way of amici curiae. And indeed, we who are called upon to adjudicate upon the affairs of men and women in their relations with one another and between them and the state are all the more privileged when served from such a tantalizing menu of ideas by the bar and the bench. Yet my discomfiture, ladies and gentlemen, with the manner in which this issue was brought before the High Court in the first instance still persists. And it bears repeating that in the ordinary scheme of things, a petitioner ought to approach the courts seeking relief on the basis of a real or perceived violation of the Constitution. But to begin by seeking a declaration that there exists somewhere in our psyche, beyond and above the Constitution, a doctrine that is nonetheless applicable in our legal system and which we have to take cognizance of even as we embark upon the determination of whether certain actions or omissions have violated the Constitution, is to lead judges onto a terrain hitherto uncharted. It is my firm view that this prolonged debate has been agonizingly stripped of the discipline of judicial inquiry. First, through what I consider to be the conceptual profligacy of elevating a notion to a legal doctrine and embellishing it with an extra-constitutional force of law, and then quite inexplicably attempting to locate the minted doctrine into the text of our Constitution. So on the one hand, we are treated to what I can call lyrics of contextualism, while on the other we are strung with thirds of textualism. And so the orchestra, in my view, goes on, which, if not choreographed, could unleash an interpretative odyssey, or maelstrom, if you like, attempts to wriggle therefrom by those to come after us, which could end up in theatrical ignominy. All this while, scant attention has been paid to what I consider a majestic directive principle in our Constitution, a tool of analysis that, faced with such questions as the ones I have posed, a court of law must deploy. And I make reference to Article 259 of the Constitution, the marginal note of which reads, construing the Constitution, or construing this Constitution. And instructively, this provision is preceded by another, which I consider as a defensive armor gifted to our vigilantes of democracy and the rule of law. And this is Article 258(1). And so I go on and on that by the end of the day, in answer to the issue as so formulated, I arrive at a conclusion to the effect that the so-called basic structure doctrine is not applicable in Kenya. I go on to consider the extent if it is so applicable, but having arrived at that conclusion, I then limit myself to some of the statements and pronouncements that were made by the two superior courts, that is to say, the High Court and Court of Appeal. In this process, I arrived at a conclusion that, contrary to what was decided in error, if you ask me, there is no provision in our Constitution that is unamendable. The question for us to ask is whether the Constitution of 2010 has within it comprehensive provisions, directive principles, and normative prescriptions which are capable of withstanding any efforts from whichever quarter of abrogating it, distorting it, or fundamentally changing its equilibrium. That is the question that we should ask. And when I asked that question, I arrived at an answer in the affirmative. So that leads me to the next issue, whether the president can initiate changes or amendments to the Constitution, and whether the constitutional amendment can only be initiated by Parliament through the parliamentary initiative. In agreement with my colleagues at the High Court and Court of Appeal, I am of a firm opinion, having read the relevant provisions regarding that issue, and in context, I am of the opinion that the president cannot initiate what is referred to as a popular initiative under Article 255 and Article 257 of the Constitution, because those articles talk about an initiative to amend the Constitution by the people. And the word people here is not an ornamental one. It is a serious expression of what forms what we consider a social contract. And both the High Court and Court of Appeal held that such an initiative is reserved for what they call the common uh,